All right, it's 10:30. Hi, everyone. Thank you for joining, and big thank you to Patrick, our trust attorney. I've been working with him personally, and so have some of my family members. And he was highly recommended to me from actually 3 different people before we ever met, 3 completely independent people. So that meant a lot. I think when you have any sizable assets, whether that be a home or stock or cash, whatever it is, it's really important to protect them. I think, especially in the wake of what happened yesterday with Silicon Valley Bank, it's a little scary to think that you could have assets of more than $250,000 and that they are potentially not protected. So before we get into Patrick's presentation, I think it's really important that we actually address that right now, because I don't know if you've heard, but when you have any cash at a bank in excess of 250,000, it's not insured, right? But one thing that I have heard, and I wanted Patrick to start off this conversation with, is how do you protect that? And is having a trust with multiple people on it a way to do so? So we're going to start there, and then he's going to go into his presentation just in general about the process of creating a living trust, who should do it, why, how, So if you have any questions, please put them in the chat. We will answer them at the end. And I'm also recording this, so we'll send it out after with Patrick's presentation so that you can refer back as a resource. All right, I'm going to hand it over to Patrick.
Thanks, Roxy. Hi, everybody. I'm Patrick Bartelmie. I'm an attorney here in Los Gatos. I'm a local kid. I grew up here between Willow Glen and Los Gatos. Went to high school at Los Gatos High. Still have my office here. Still live here. So that's some quick background, I guess, on me. But we have a small law firm here in Los Gatos. There's 3 of us attorneys and some support staff. We're what you would call a boutique law firm, probably, but we focus on estate planning. That's really our big item over here. It's vast majority of kind of what we do. We also do a little bit of tax work. We do a little bit of business transactions, helping people form entities and comply with formalities, anything you can kind of think of as far as business law goes. And then I also do some real estate transactions. So I help people transfer property off market, help people with deeds, help people like Roxy when they run into problems with certain items. And it just generally practice in that, because all 3 of those things are related. So very often we're doing those other items for estate planning clients. So that's who I am in a nutshell. Today, what we're going to talk about is your core estate planning documents, right? How do you get started with your estate plan? And then for some of those of you who may have already done this before and are coming back to it after a while, you'll kind of get a refresher on what it is now, right? The law is constantly evolving. Strategies for estate planning are constantly evolving. And so you'll get kind of a refresher on how we're doing things these days, right? So what I'm going to do now is just share these slides on the screen. And if for some reason you guys can't see those things, holler at me. But here's our starting page. So you'll kind of get a breakdown here as we go through. We wanted to touch on, obviously, the Silicon Valley Bank issue here. It's top of most people's minds around the Valley right now. Incredibly shocking developments, right? When you see a $200 billion market cap business disappear overnight that holds a lot of people's not only personal loans, personal bank accounts, but also a tremendous amount of business capital that's necessary for the day-to-day operation of a business, right? It will greatly impact a lot of people's lives. And so we will, obviously do our best to address any questions you guys have on that area. It's a topic that we could probably spend 3 hours talking about without even pausing, right? Because it's just so wild. Now, I don't pretend to be a financial professional expert by any means, so I'm not really the guy as far as how did this happen, but what I can tell you is best practices for your estate planning and personal assets. One of the big steps that we're going to go over in the slides here today is funding your trust, and some different examples in how you do that. And so when we get into that, we'll definitely talk about, you know, FDIC insurance limits, strategies around, you know, not getting caught with more than that in one account. You know, what I've seen people do over here in, you know, my experience, which includes drafting about 500 estate plans, helping people fund those plans, helping other people who come back to, you know, amend plans, you know, and then obviously, you know, just day-to-day sort of working with clients in this area. So please feel free to kind of shoot some questions at me if you have them in that regard as well. But I will get into a little bit more detail on it when I get to that slide that talks about funding of trusts. So we'll kick this thing off with your three major reasons, right, of why we get into estate planning, or sort of overview here, our first section of the slides. And these are all, you know, incredibly important sort of areas. There's one of them, the fourth one, that's the most obvious that we put at the end, because I kind of like to just, I think everything else kind of flows into it, but that is carrying out your wishes, right? So what do you think of when you think of drafting a will or a trust? It's making sure that your assets are passed on to the people you want them to go to, right? In the most simplest of terms. So that's what we'll get in number 4. But the first 3 here are your you know, kind of technical reasons of estate planning. So for each of us, the law in California has drafted a will. That will is called the probate code. It's a, you know, very long section of laws that basically determines what happens with people's assets if they don't go and do their own estate planning, right? And so ideally, you're doing this yourself. You're not leaving it up to the government. Leaving anything up to the government, obviously fairly dangerous, usually not very efficient. And so here's how you take yourself out of that system, right? You in California go and you draft your estate plan. What's an estate plan? It's a set of documents that protects you from these certain different areas of the law where the law will step in automatically if you don't do this, all right? So the first one is probate, right? The probate system. The probate code is the set of laws that controls the probate system, right? In California, you need to have a living trust, and it needs to be funded and properly executed in order to avoid probate. If you draft a simple will, or you do nothing at all, and you pass away, your estate goes through the court system in order for your assets to be distributed. All right. With a living trust, we can do all of those things that someone has to go to court and ask for permission to do with simple paperwork inside of a law office. Right. So you save yourself a ton of time, a ton of money, and a lot of heartache, really, in not dealing with that system. And so there's a few bullet points there on why to avoid it, right? Probate is done on what we call a statutory fee system. So it's a percentage-based fee that's set by the law. You can estimate it roughly at 5 to 7% of, you know, this is obviously a rough estimate, it's different for each case, but 5 to 7% of the assessed value of your assets upon your death. Meaning that if you own a piece of property, right, you own real estate, and you carry a mortgage on that property, the law for probate does not take into account that the fact that maybe you don't have, you know, 100% equity, you have a loan or some debt on that property, right? They only care about the fair market value of the property as of your date of death in calculating these fees. So anyone around here that owns property knows it's incredibly valuable. And when you start tacking on percentage-based fees of 5 to 7%, the fees are dramatically high, right? And so that second bullet point there gives you a quick example, right? An estate with an appraised value of $1 million, which is most land around here, right? As of the date of death is going to pay approximately $47,000 in fees and expenses to get through the probate process. This could be one house, right? That rises to this amount of fees and expenses. The typical cost of an estate plan is probably in the $3,000 to $5,000 range. That's your comparison figure here, right? So you can go and do this yourself, or you can leave it up to somebody to take care of it after you've passed away. And this is roughly what it'll cost them to do that on this size of an estate. It takes about 12 months to get through probate right now. You're required to have at least 2 hearings. You have to have an initial hearing. You have a 4-month creditors period after that hearing, and then you have to get another hearing typically in order to resolve the entire matter, right? And right now in Santa Clara County, we have sort of 1, maybe 2 at times courtrooms for probate and judges. And that is a very backlogged and incredibly busy area of the court, which means it takes about 3 to 4 months to get a hearing date. So incredibly long amount of time, right, for assets to be tied up and unavailable essentially to beneficiaries while you're waiting for this court order from a judge to distribute the funds or the assets to those beneficiaries. All this avoided by drafting a trust and completing the funding of that trust by changing the title of your assets. So that's our first big one, right? And it's sort of the first overarching technical goal, right? The second piece of this one here is called probate conservatorship. So when you've passed away, your will and your trust are your controlling documents. If you become incapacitated, so you're alive, but you're unable to communicate your desires for medical care, or you're unable to take care of yourself financially, we have a system in the probate courts called conservatorship. The most famous example recently being the Britney Spears matter that's been in the news for the last few years or so. So what happens if you can't take care of yourself is that either somebody is appointed by the courts, they have an entire back office of people that do this in each county, and they will go to a judge, they will ask for these orders, usually on the recommendation of a social worker or somebody like that, and they will become your conservator. They will decide when, where, how you receive medical care. They will access your personal finances in order to pay for that care and then sort of maintain the assets, right? Make sure your bills are paid, things of that nature, right? And that is obviously a less than ideal situation, because in that, in those, decision-making roles is somebody you've never met before, who is also constantly charging you, typically in an hourly fashion, like an attorney or an accountant would do in most cases, to do this work on your behalf, right? So they're draining your estate, they're making these incredibly personal decisions for you, all the while you are incapacitated and basically don't know what's going on, right? So how do we use an estate plan to avoid this? We use power of attorney documents, right? A durable power of attorney for financial decisions, durable in that it survives the event of your incapacity, right? Advanced healthcare directive is the other document we use, and that's the one we will use to control or name an agent to control our medical situations for us, right? They will make these decisions for us. They will decide the care we receive, where we're living, these different kind of things, right? That you just really would never want a stranger doing for you. So that's how we avoid a conservatorship. The third one, it's kind of tiny down here, but for most estate planning purposes, it's usually the biggest one as far as a bill can go, and that's taxes, right? And there's 3 different types of taxes that we sort of address in your core estate planning documents. The first one is the federal estate tax, which is a tax applied to everything in an estate above the exemption amount in the year that the person passes away. And it is the single highest rate in our tax code. It's 40%, right? Right now, it's become a different type of concern for most Americans in that the number sits, the exemption amount number sits at $12.92 million, right? It doubled in 2018 with the introduction of a new tax bill, and it has been tied to inflation. So from 2022 to 23, you can imagine, due to the wild inflation in our economy, the number went up, I think, about $700,000 in 1 year, which was pretty dramatic, and it is a very large number. So each individual is granted this exemption amount. You can use it during your lifetime and at your death combined, so you can make lifetime gifts and use part of it, and whatever's left over in the year you pass away, that's your lifetime exemption amount. So you can gift up to that amount of money to anybody you want without them paying the federal estate tax, right? So this is obviously a big one because the rate is so high, right? We intentionally structured trusts so that for a married couple, there is no tax due on the death of a spouse, the first spouse to die, and ideally, there is no tax due to the beneficiaries when the surviving spouse passes away as well, right? So that's your federal estate tax in a nutshell. Obviously, a very intricate conversation that we can spend a lot of time on as well. There's some other parts of it addressed in that in that paragraph bullet point there. Kind of the big one that's looming for people with sizable estates is this tax bill is set to sunset in 2025, meaning that it would go back, the rates and exemption amounts would go back to where they were in 2017 when this came into effect, if nothing else is done before it expires. The rate when it was doubled was about $5.5 million. So if we go back to that range, all right, it changes a lot of the perspective for a lot of people as far as whether or not their estate is taxable. And so it's something that, we're a conversation that's ongoing, and it has been in the history of estate planning, because we've had this tax for, I think, over 120 years now or something like that. And essentially this rate has fluctuated throughout history almost constantly in that 120 years. So you have this huge fluctuation, you especially have it in the last 15, 20 years, quite a bit of change, 25 years. So a moving target, but something that we plan for. The other two types of taxation that we're concerned with in estate planning are capital gains parts of income taxation. And the major one there being, we do our best to ensure assets are entitled to stepped up basis rules upon individuals' deaths, meaning that if they leave an asset to somebody, that person, that beneficiary inheriting the asset is going to be entitled to a step up in basis from whatever the gifting party or decedent purchased essentially an asset for versus what the fair market value is as of the date of death. So for a lot of people in the Silicon Valley area whose parents purchased real estate a long time ago, this is kind of the most common one around here, or who invested in stock a long time ago in certain companies where we've obviously seen tremendous growth in both areas, you have a large unrealized gain in those assets for capital gains purposes. That gain can essentially be wiped out if you are entitled to a step up in basis. Assets gifted through trusts can be entitled, and generally are entitled, to that step up. So that's our other big one that we really focus on in estate planning and want to make sure that we can capture if possible, because the tax savings are tremendous. And then the third one is your county property taxes, right? Can we transfer real estate with exemptions from reassessment, right? And that can often be a very high value transfer as well, or exemption, because if again your parents purchased property a long time ago and they're paying $1,000 a month in real property taxes, or sorry, a year in real property taxes, you can avoid it going to $1,000 a month or more, right? If you can confirm one of these exemptions through your county property tax agency, right? Your assessor's office. So that's our taxation piece, right? And that kind of wraps up our third item there. And then the fourth one, here's the big one, right? That I touched on at the beginning. And it's the most obvious one, right? Your estate plan should carry out your personal wishes. It should make sure that the individuals you've named in the documents are properly put in place to take care of you and your assets, or your children if they're still minors, right? In the event of your death. So that's number one, right? We want to place people in positions of power to carry these things out outside of the court system, right? And eventually we want that same person under your trust, your trustee, to distribute your assets in the manner in which you desire, right? Before you pass away. I want my house to go to my kids. I want my money to be available to them to go to college, right? Your most simple, basic desires should be properly carried out in your estate planning documents, right? And so there's a fun little exercise here to kind of get the ball rolling for you if you've never done this before, right? If you've never drafted a will, you never drafted a trust, you've never sat down with an attorney or anything like that. Here's a couple of questions and a couple of paragraphs for you to read and contemplate later on, and sort of, you know, think about how you would want these to play out for yourself. Okay, moving on to section B here.
Hey, Patrick, really quick. I just want to reiterate, thank you. That was really helpful. I learned a lot right now. I wanted to reiterate about the probate really quick, because I think this is, to me, something that's so misunderstood, that you can have a will and you can still, you know, pass, and all of your assets still have to go through that probate process. So just those high level points again, you can't avoid it even if you have a will. I've heard the average time you're saying is 12 months, and I know people that have gone through it for sometimes up to 3 years. Yeah. And the fees are not based on, like, for a house, that was a really good example. Your house could be worth 3 million and you might owe 2 million on it, but those probate fees are all based on that 3 million. They don't take that debt into consideration, which is really crazy, that it could be like $150,000 in fees on an asset that you only actually have equity of $1 million in, you know? So yeah, kind of blows my mind.
It can create liquidity issues. It's a really big problem. And this is obviously for all of you guys joining, this is the area where Roxy and I's professions cross over most often. The things her and I would work on more often than anything else is Roxy selling a property for a personal representative of an estate in probate that I am representing. And so, you know, as a real estate agent, you will, you know, run into these things, and you'll see, you know, she has a lot of perspective on these issues and the problems it creates, because people don't realize that they have to do this, right? You have to go to probate in order to be able to sell a property.
Yeah.
People will engage Roxy, other realtors. They will prepare properties for market. They will even go to market and accept offers without the ability to sell, because they don't realize, right? I have to have a court order and permission from a judge to be the representative of this estate in order to sell this property. So yeah, there's a lot of landmines in probate and real estate. There's no question.
And I think it's just hard for people to wrap their minds around. And I think it would be for me too, of like, this is my family's property, right? Like how do I not have the right to do what I want with it or to sell it, if even that was the wish and intention of this family member or spouse or whatnot. And I think when you're already going through something so emotional, and then you have that to deal with, it's extremely frustrating. So yeah, I've done a few probate sales, and the process, if you need court confirmation and all that, is extremely different. The paperwork is different, and it's another complication that can be easily avoided. So yeah, thank you. And then my other question was, and maybe you're not the right person to ask about this, but I had this personal question of, for the, representation, if someone in your family, has dementia or Alzheimer's or whatnot, and now you're saying you might have to go through this court-ordered process of having someone assigned for their benefit. If there is someone who is of mental capacity to do that, do you still have to go through that process if there's not a trust? Like, does it add also another layer, or?
Yes, so you will still have to go to the courts. A family member can do this, and thank you for clarifying this, because I skipped over that piece of my explanation in the conservatorships. So I'll go back up real quick to what we're talking about, and it's number 2 here, probate conservatorship. So what I should have said in my introduction of this section is that if you become incapacitated and nobody goes to the court on your behalf to ask for these powers, then the county steps in, right? So absolutely, a family member can do this. They cannot do this without the court's permission, without a court order, right? And so it's the same scenario or rules that the county people, the county workers would fall under, that your family member or friend would fall under, right? It's just wouldn't necessarily have a stranger doing it, right? And we avoid this completely by drafting those documents, the healthcare directives, the powers of attorney, and making sure that we have agents in place underneath those documents, right? That negates the need for a conservatorship along with the trust.
Yeah, it just feels like so often we just don't have the information to know what to do, and that's, I think, what's hard. And even after my grandfather passed last year, and getting the insurance money, and filling out this confusing paperwork and all of that. I mean, that's, for me, having support and an advocate and an expert like you to be able to ask these questions and know you're not doing things in the wrong way, I think is really valuable. So I'm glad you touched on that, because I wasn't aware of this.
Yeah, thanks for that clarification too. Okay, so section B down here is the list of the documents that make up your estate plan, right? We like to call them your core estate planning documents, because this is where everybody begins essentially their estate planning journey, right? You may have done other things before this, but in California, this is really what you need if you own a house or you have an asset that's worth more than $162,000, and you don't want to put it in some sort of joint tenancy or automatic transfer on death type of titling, right? We use these documents to create your estate plan. Once you've done this, you are exempt from probate, and your individual power holders under each document, which would be a trustee for a trust, an executor for a will, and agents under your powers of attorney, they can affect the transfer of these assets and basically administer your estate without any sort of court involvement, right? And with, obviously, generally done with the assistance of an attorney, with a financial advisor, a CPA, right? All your classic, your real estate agent, all of your classic, right? Personal services individuals that would help you in your own life while you're doing these things yourself, right? Buying houses, dealing with bank accounts, doing all these different things that you do in order to, maintain your finances, right? So the first one here is the most important one, and that's your living trust, right? This is the document that will carry out your wishes. It will have your gifting procedures listed inside of it, right? It will have all those things done as far as, I want this to go to this person, right? It will protect your estate from probate and conservatorship, because conservatorship is a two-part situation, right? Conservatorships are essentially guardianships, right, for incapacitated people. So if you've ever dealt with a guardianship matter, you will recognize these terms, which are, there's a conservatorship of the person and a conservatorship of the estate being their assets, the person being the day-to-day decision-making on, here's where you should be living, here's where you should be receiving care, et cetera, right? So you have these two things. A trust will negate the need for a conservatorship of the estate. those powers of attorney documents negate the need for the conservatorship of a person, right? So that's where the trust falls into that breakdown as well, right? If you have minor children, a living trust really shines beyond a will because you are allowed to make conditional gifts over, longer periods of time and in a different type of manners than you would be in a simple will, right? Meaning that you can leave assets in the trust under the control of a trustee other than yourself or anyone else that's a trustor of the trust, a creator of the trust. And that way the assets can be protected from premature inheritance or passing on to children before they are ready to inherit those assets, right? That's a major one for a lot of people. And, a big reason that brings people into my office initially, right? The two most common things I hear from people when I meet them the first time are, we just bought a house or we just had a kid. And so that's right down the alley of, all right, perfect. You've come to the right place. This is exactly what you need, right? So that's your living trust, right? In a nutshell, it's going to be the longest document in an estate plan generally. And it's going to do all those things that you think of traditionally a will taking care of, right? It's going to hold your assets. It's going to determine where they end up, and it's going to protect them as you see fit throughout the years. 1A here is your schedule of assets. So on the back of every trust that I draft, and ideally every other attorney as well, is going to be a complete list of your assets, right? And we do this for a couple of reasons. The first one being, we want to subject those assets to trust ownership in most situations, right? We want to avail the asset of the probate protections of the trust. So the way we do this is generally by changing title to the asset, right? Step one, listed on your schedule of assets to your trust with the intention or a statement of intention that you mean for this to be a trust asset, right? So that everything gets listed there, everything is dialed in, you've signed it. And essentially, if you don't go and take the second step, which is traveling to the bank to change title to an account or drafting a trust transfer deed and executing that and recording it, right? You can use these documents to transfer assets after people have passed away without probate, all right? So that's the big reason for maintaining, keeping, and drafting a schedule of assets to your living trust. All right, after all this talk about, how you don't want a will and you want a trust, well, all of us are still required to have a will in California. So we use a specific or a special kind with your living trust called a pour-over will. So it has one important provision in it that says, I leave the residue of my estate to my living trust, right? You're essentially making your trust the beneficiary of any assets that you don't title into the name of the trust. So again, creating a safety net from probate, right? That's really the only purpose of this document, right? The other thing it does is it protects the privacy of your estate plan. So your living trust, it's a private document. It's not filed with any government agency. You don't have to give it to anybody you don't want to. And so upon your passing, essentially, as long as it's never litigated and it doesn't become part of the court record, your entire administration of your estate will remain private, right? The only thing that gets filed with the court is your will. And so we lodge a will with the court when people pass away, we call it, right? We take it down to the courthouse and it becomes part of the public record in that manner, right? When you have a pour-over will, all it says is I leave my assets to my living trust, and that's it, right? No one else can glean any other information from it. So a privacy protection document in a way, but for the most part, it's there to just comply with the law and create this safety net from probate. The third document there, certification of trust. This is in essence a privacy protection document. It's a high-level version of your trust that you will use in proving the existence of your trust to financial institutions and other places where you're changing title to assets into the name of your trust. without giving them a complete copy of the trust in order to protect the asset and gifting information that's in the trust itself. And that's, it's not generally one you're going to use all that often. It's used a lot at the beginning. It's used certain times in administrations. Otherwise, you have it in your back pocket to kind of help protect that really important private information inside of your trust. Number 4 is where we're going to get into your trust funding discussion here, right? And we'll wrap in the Silicon Valley Bank discussion here too. So this is essentially the practice of funding your trust after it's executed. A trust has to own an asset to be valid in California, right? As a part of my practice, when anyone owns real estate and they draft their trust, I draft a trust transfer deed that's executed on the same day as the trust and recorded with the county immediately, right? Real estate is most of our most valuable asset, right? And so, especially around here, and for a lot of people who, invest in real property, have multiple properties that they own, et cetera, this is an incredibly important step because it is usually, the biggest factor in determining those probate fees. So we want to make sure right away that we get the real estate transferred in there. And it's kind of the most common example of what we do as far as attorneys, right? The rest of this falls on the client as far as trust funding goes, as when it comes to bank accounts or financial institution accounts, because obviously banks aren't going to talk to me about your accounts or anyone else, ideally, right? And so that's where you get into, the client's piece of the work here as far as funding goes. You'll go down to the banks, Wells Fargo, Bank of America, wherever it might be, right? And you'll tell them, all right, I have these accounts here. I want to transfer these accounts into the name of my living trust because they carry more than $162,000 in them, or whatever reason it is, right? 162,000 being our probate asset limit in California. So that's your trust funding kind of breakdown in a nutshell, right? How do we wrap in, okay, I keep multiple hundreds of thousands of dollars in one account, right? As far as Silicon Valley Bank, for example, goes, how do I deal with that on behalf of my trust? Well, FDIC rules, right, or your Federal Deposit Insurance Company rules, I believe, are such that, right, you're granted this $250,000 of insurance for each account owner. As far as trusts go, you have one owner in the trust, but you'll have the trustee names on the accounts as well, right? The person that's entitled to act on behalf of the trust is the trustee, right? For all of us that are living and competent and have a living trust, that's generally us, right? We act as our own trustees until we're no longer able to do that. So you, in dealing with the banks, are going to tell them, I want this many accounts, right? If there's one trustee, you have one person entitled to insurance, multiple trustees, multiple people entitled to insurance, et cetera, right? But I think the most important thing to realize here with this, news yesterday is that there's a lot of people that got caught sort of with all the eggs in one basket, right? We have, you see a lot of examples in the news yesterday of companies that had one bank account at Silicon Valley Bank, and we have $5 million or $10 million inside of it, right? And it's because we're a small startup bank or startup company, and we have one bank, and we have 6 people running an entire company where we're each wearing 5 different hats, and we're just trying to make this thing work, right? And I think that's what sets Silicon Valley Bank apart from where most of us as individuals probably bank on a regular basis, right? The vast majority of their business was these, startup stage companies and people that were, working on their behalf, because what that bank was really known for, that, almost no other bank in the world does on that scale, is lending to those type of companies and the people working in those companies. So if you were a startup founder recently and you said, okay, I need I need certain loans, I need certain, things to buy my own house. I need a line of credit on a property I already own in order to help fund this business, right? Silicon Valley Bank was helping people do that, but what they were doing was requiring you to do your day-to-day checking account type of banking inside of the institution, right? And so that's why so many people have gotten trapped here, right? Because they were forced to be using that bank for not only the loan and the lending type of stuff, but also their day-to-day business banking or personal banking, right? For most of us, we're spread out, through a couple of institutions. Typically, there's one for your day-to-day banking. Typically, there's one for your investments, and then maybe also, but sometimes a third one for your retirement accounts, right? And so what we'll do is list all those on your schedule of assets, and we talk about the need to retitle them immediately, or the need to address beneficiary designations for tax-deferred retirement accounts or life insurance policies, right? Which you don't change the actual ownership of when you draft a trust. You potentially change the beneficiary designation on. So the strategies as far as availing yourself of FDIC insurance, et cetera, right? It's basically making sure that you don't have more than the insured amount in any one account. And what I've learned in the last day or so is that there are alternatives, right? There are sweep style accounts where if there's one person's name on the account and there's a deposit that takes the balance over $250,000, these accounts will automatically sweep your balances into other accounts that you own, so that you maintain that level of insurance, right, over all of the different accounts. So that's a good option that was kind of an eye-opening one for me. I never heard of, right? And then I think the alternative is just, doing that yourself, right? And making sure you're keeping an eye on it. And then if you are going to keep a, rather large sum of money in any one account, that you're hyper conscious of the institution you're doing that in, and making sure that it's, if you can in any way sort of hedge against that, right, that you're doing it. Because if a $200 billion business can go away overnight, right, a lot of different banks might be sort of subject to this same kind of madness, because that's really what took Silicon Valley Bank down, right? Was a rush on the bank to withdraw funds. No bank has 100% of deposits on hand to return for withdrawals. That's not how they run that business, right? They make money off of the money we deposit into the bank by reinvesting it into other assets. So as long as you're aware of that, and kind of know, look, all right, even if there's a run on the bank, I'm okay. The government might shut it down like they did here and hang on, freeze withdrawals for a certain amount of time, hopefully not a very long amount of time, but ideally all your eggs aren't in that one basket like some of these people got caught with today. So hopefully that provides a decent breakdown on that for you guys. And then here's the other last two documents that we've touched on a bunch today, right? Which are your healthcare directive and your durable power of attorney for financial decisions. So your healthcare directive appoints an agent to make those medical care decisions for you. And most importantly, or really importantly, it allows you to determine ahead of time in writing whether or not you want to be kept on life support if you have an incurable and irreversible condition. So two doctors have examined you. They both agreed that that's the diagnosis. And in this event, right, we can make this decision in writing ahead of time so that there is no burden on your family members or friends or someone else to have to do that for you, right? And so that's a big deal. And then the other thing we do inside of these documents now is state any sort of desires for funeral or burial wishes, right? Cremation, celebration of life, all those different things. You plug all that into this document now, and your agent under this document is empowered under California law to carry out those wishes for you. A durable power of attorney for financial decisions is the flip side for finances, right? This person accesses your accounts. They can move things into the trust. They can keep things, the things that are in your own name, they can move into the trust. They can keep things there, but basically their main role, right, is to use your money to pay for your care so that no conservator of your estate is necessary. All right, and that's it. That's the breakdown.
Lots of info.
Yes, it's a lot. I know it's a lot, Dan. I go kind of fast. I'm sorry, but
No,
more than happy to answer any questions you guys have.
It's so helpful. It's so much good info. Question, if someone already has a trust in place, but hasn't looked at it, I mean, I don't even know, like how often should you be looking at it, updating it? And it sounds like a lot has changed even in the last 10 years, 15 years. So at a bare minimum, like what would you say is the year that if someone hasn't updated it, that they really need to? Because I have heard of weird things happening where you have a living trust in place, but maybe it's 20 years old, someone passes away and there are a lot of complications because it was based on old laws.
Absolutely. I mean, so we've seen tremendous amount of change in the taxation of trusts in the last 10 years, especially. That has brought a lot of people in to amend their living trust, right? We used to see an A-B setup, we call it a split into two different trusts after the death of a spouse in the vast majority of trusts, of living trusts that were drafted, 15 years ago and beyond. And that has become less ideal because any assets put into that second trust are no longer entitled to a step up in basis after the death of the surviving spouse. So we do a lot of work in order to change that, not just by amending trusts that people are currently sitting on that say that, but also by going to court and getting court orders to do it after someone has died. So that's a big deal, right? If your trust is no longer in a line with your ideal taxation setup, then yes, that's a major factor, right? And that's probably something you want to look at a minimum every 10 years, or if you hear that and see a letter from like your attorney's law office, right? We send out letters when there's big changes in the law. Hey, did you see this? Are you aware of what your trust says? If we drafted it, we'll tell you, right? And then, you may want to examine this or come in and talk about it, right? Those major events or triggering events are really important, but the most common ones are family events that we see, right? Say you come in and draft your trust when your kids are minors, right? And they reach maturity and they're, well-functioning adults, so you would trust to do all these things themselves now. That's a really common one I see, right? As far as coming in to re-examine what you have in place and making sure it's in line with your current desires. And then the other ones can be as simple as, look, I listed these people as beneficiaries, a long time ago, and I don't want to leave things to them anymore, right? It can be as simple as that, or changing your trustees, right? There's a lot of reasons to do it. There's no one kind of timeline to do it on. The one thing you want to look at consistently is that schedule of assets attachment to your trust. And so that's 1A here. If you change banks, if you open new accounts, if you buy and sell property, you want to make sure you keep that list up to date, right? I like to call this one the most living part of a living trust because it changes the most often, right? For almost everybody. So that's the one you'll see, almost constant changes or revisions done to, and it's done as a schedule or an attachment to your trust, so that you don't have to formally amend or re-notarize your signature on amendment every time you change one of those accounts, right? It's just a regularly signed attachment to a trust that can be updated whenever you want.
That's great. I don't think we've had any questions yet, but I think for me, in thinking about real estate, just for any of you who are on here that they don't have a living trust but do own property or plan to buy property, which is, I believe, all of you, please note that when you have your living trust set up, as Patrick said, they'll write something up so we can transfer and record your property now to vest into your living trust. That's really important, because having a living trust and having the intention of all of that, you're going to add a layer of complication if you forget to actually transfer it. Same with your bank accounts, as he said, right? So be sure to keep that top of mind. And when you're thinking about doing this, to, ensure that that happens. And if you have questions about how to do that or what the process is, you can always contact me. And your trust attorney should be able to help you as well. And Patrick, how long do you think it takes to get a living trust set up?
So it depends on the individual client generally. So we'll have an initial consultation for the most part, get to know each other kind of meeting for me and most of my clients. And then after that, you go into an information gathering stage. I've got a really thick packet of questions. Roxy's seen it before that I have people fill out for me. And I populate a set of drafts based upon those answers. It only takes me about 7 to 10 days to get a complete set of drafts put together. And so after that, we'll sit down, meet again, talk about the important parts of those documents, where your answers on the questionnaire translated to the actual documents. And then a couple of changes might be made generally after that meeting. Some clients want to, read through the entire things on their own. So I let the client kind of dictate the timeline after that meeting, and then turn around, come back, have a signing appointment, execute the documents and the deeds, and then it's essentially done at that point.
Great. Yeah. So it sounds like the bottleneck is just us trying to make
oftentimes,
make these decisions, gather that information, and I think that
for everybody else, it's a little different, right? Deciding on who you're going to name to these positions and the different things you're going to want to do, right? It takes, it takes everybody a different amount of time and a different, level of commitment to making those decisions sometimes. So that's usually the determining factor in getting these things done. I've done estate plans in as fast as 2 days for people who were having emergency surgeries, things of that nature, right? I've also seen clients come back 2.5 years after I've given them a set of drafts. So it's a wide range. Generally, I'd say it gets wrapped up within a month.
Okay, that's really helpful. So everyone who's still on the call, thank you for coming. And I'm going to send out this presentation. Patrick's information is on here, and I'll put that in the body of the email as well so that you can reach out. But I do highly recommend everyone to really, it's not a question of if you should do it, but how quickly you should do it and, protect yourself. I just can't think of anything worse than someone from the government telling me what I should do with all of my assets. I hate it. So thank you guys again. Patrick, thank you for your time on a Saturday. I mean, that's a lot to ask. You have a family, so really appreciate it. And I don't think there are any more questions, so I'll send this out to everyone, but thank you for coming, and feel free to reach out to either of us, both of us, with any follow-up questions. And I would assume, and I just want to verify, Patrick, this is probably different in every state, right? So if they have a family member who they want to encourage to be doing this or thinking about this, it should differ based on the state in terms of how they go about it.
So if you're a permanent resident of a different state, you'd want to contact your attorney there. There are different rules for these power of attorney documents and things of that nature. And then California is a community property state. And so that's also a big part of our conversation for married couples and estate planning, right? And we're one of only about 10 of those. So there's definite differences on a state by state basis. If you do draft your trust here and you move to a different state, it's still going to be given weight there, right? It's still okay. You can travel across any state lines with a California drafted estate plan. But if you're already living somewhere else, better to find an attorney there.
Okay, great. And you guys, if you guys need recommendations for attorneys in other places, maybe Patrick could help with that too. So we
have some of them here. Yeah, absolutely.
Yeah. Just use us as resources as usual. There's so much to figure out. So, all right. Thank you again for your time on a Saturday. Thanks everyone.
Thanks for having me, Roxy.
The recording, the presentation, contact info, and have a good day, everyone.
Take care.
Bye.